Welcome back to the 100 cases. In this video, we'll talk about the case of Rajnesh versus Neha. And if you want to check out this case in a descriptive manner, please check out the link in the description and make sure to subscribe to this channel because we come back to you twice every week. So before getting into the facts of this case, we must know what was the background of this case, what really made this case special. So as you guys know that there are many ways by which you can grant maintenance to the wife. There is Hindu Adoption and Maintenance Act, Hindu Marriage Act, Domestic Violence Act and CRPC and a few more. So what the problem here is that you can get maintenance from one act and also from other act. Like you can get maintenance from CRPC as well as from Hindu Marriage Act. So there is a lot of overlapping of jurisdiction. And during the procedure of the case, there can be overlapping of orders or there can be conflicting orders passed from the court. So in order to stop those conflicting orders, the court has given guidelines in this case. So let us move towards the facts of this case. So what happened in this case is that the wife and the husband got divorced in the year 2013. And in year 2015, the wife was granted maintenance of rupees 15,000 and rupees 10,000 for her son. The husband didn't pay the amount of maintenance, and in year 2018, he filed an appeal in the High Court. And he pleaded that he would not be able to pay this much amount of maintenance to the wife. But what the court said is that they rejected the petition and ordered the husband to pay 3 lakh as the arrear of maintenance and 2 lakh as interim maintenance to the wife. And after that, the husband went to the Supreme Court. And then he pleaded there that he has not enough money to pay wife. And even though he has no assets, he has many liabilities. And due to which he would not be able to pay this amount. And if he would have to pay this amount, he would have to sell the properties of his father or take loan from his father. And on the other hand, wife pleaded that she has no source of income, she has no property, and now she really needs that maintenance amount to maintain herself and her child. And now in this case, the court gave certain set of guidelines which should be followed throughout the territory of India. And the first guideline the court gave is that if there is any case for maintenance, then both the parties must tell the court if there is any previous case for maintenance or if there is any previous order or current proceedings regarding the maintenance. So by which the court can consider that how much more maintenance the wife needs and how much the husband is capable of giving. And the second guideline for the parties is that both the parties should tell the court all the information regarding the maintenance, and the information should be given by a sworn affidavit. And in that affidavit, they should tell all the information regarding the marriage, regarding their income, regarding their assets and their liabilities, which will make easy for the court to understand both sides, and then the court will give a reasonable award for maintenance. And the third guideline is that in case of interim maintenance, the court must complete the proceedings under 60 days. Because in the case of interim maintenance, the wives need the money or the maintenance amount urgently. That is why the interim maintenance suit is filed. And if they cannot get the amount and their proceedings will go on more than 60 days, then it will not be beneficial for any of the party. So the proceedings must be completed under 60 days. So these are the 3 set of guidelines that are issued by the court in this case. I hope you have understood this case, and thank you for watching this video, and make sure to subscribe to this channel.